Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altishan, Director of Client Partnerships here at Pacific Cascade Legal. And today we have attorney Andy Kralios to talk about the 4 stages of a personal injury case. So, Andy, before we get in and talk about it, go on and tell us just a little bit about yourself.
Sure. I was born originally in Salt Lake City. My parents are immigrants, and I went to law school back east in Massachusetts on a scholarship. And one of at my first job out of law school, I was hired out of law school to do insurance defense at a large firm that was based in Boston. And they would defend a lot of the cases that we're going to be talking about today. They would defend car crashes, but also medical malpractice. So I kind of learned on the other side to begin with. And I think what that does is it gives me a little bit of an insight into what our clients will be facing and how to handle it.
Oh, I totally agree. So before we just kind of get into what are these stages, I want to ask you, a little bit about the need clients kind of need to have for patience. And it's hard to have patience in cases like this, but it really is important, isn't it, to have patience because it's a pretty lengthy process sometimes.
It is patience is critical. And unfortunately, a lot of times our clients aren't in a position to have patience. They owe bills. Sometimes they lose their vehicle, no longer able to drive to work the way they were before they were in their accident, or they're seeking medical care and they are missing work. So it's a very difficult balance to keep the client kind of calm and make them realize that it's typically a months long process. And if the insurance company is going to fight it, that it ends up sometimes being a years long process.
Well, so let's talk about the first stage, which I think I call determining liability. That's really important to get that down early and understand it, isn't it?
Absolutely. I mean, if you don't have your liability determination sewn up, you basically don't have a case. And so what we would mean by that is make sure it's the other driver's fault. If you get a police report or a eyewitness account that says that our client ran a red light, there's not really a whole lot we can do to help them other than direct them to their insurance. But as far as putting a claim in versus the other driver, who we call the tortfeasor, if you don't have a good liability determination, your case is grounded from the beginning.
Are there certain places you go to gather some of this stuff? I mean, the do you talk to witnesses, get court records? How do you sort of gather the information, or is it all just from your client to determine liability?
So initially, it's from our client. If they say the right things, then we typically want to get them in to sign them as a client. But one of the critical documents is the collision report that's filed with the with Washington State Police in the case of Washington, where I practice, sometimes by the local police force. That document is, for the most part, when you're at the early stages, when you're at a claim stage for a personal injury matter, uh, most of the time you'll get an insurance company to accept the liability on the part of their insured driver if the collision report shows that it was in fact their insured driver's fault. It's a neutral document, um, and it's relied on throughout the litigation. Now, ironically, it's not admissible at trial. So when you get to the trial stage, you can't just hold up the police report and say this is proof positive of the negligence of our defendant. It becomes only a part of your evidence. So the trials can end up being really complicated, even with that document.
Got it. Getting past that, I guess the next thing is to determine damages in the case.
Certainly, and that's a game of patience as well, because we only, as far as at least with medical bills and physical injuries, we're only really able to determine that once the client's treatment is either complete or reaches some kind of milestone where their regular primary care physician, or if they're seeing a chiropractor, declares you're either at maximum improvement for what I can do, that is the medical provider can do, or I'm going to recommend you for surgery and refer you to an osteopathic surgeon. And then with that recommendation to surgery, we can sometimes put in a demand for future damages and do an estimate. But the damages determination can be really complicated. One of the things that affects it that probably shouldn't is what does the car look like? The insurance companies put a huge amount of undue emphasis on whether the car is crumpled up enough. And the reason why they do it is because the jury responds to those photographs. If you have a jury doing a personal injury case, for some reason there's a almost kind of a primal human desire. They want to see a crumpled up car to gasp at the beginning of the case. If they see one where it's just a scratch on the paint, a lot of times you're going to be facing a brick wall with the insurance company paying the face value of the medical bills. But bottom line is, when we determine damages, there's emotional distress, there's other non-medical bill damages, but those always are calculated as kind of a function of what the total of the medical bills are. So it's not to say the higher the medical bills, the better the case and the more the damages, because it has to be believable treatment. If you go to a chiropractor for 2 years, no insurance company is going to reimburse you for that. But again, that emotional distress damages tends to be based in part on the total value of the medical bills.
Does lost wages come into that at all?
Absolutely. That's a slightly simpler determination. If the client allows us to contact their employer, it can be pretty easy. If for whatever reason they don't want us to contact the employer, then it can be quite a bit more difficult. But that's sort of black and white. If you can get something from the employer that they called in sick these 3 days, these 4 days, and then you just multiply what their multiply it as a equation of their salary or their hourly wage, that's pretty easy. But you also typically need a doctor note excusing them from work. So I advise my clients a lot of time that if they've missed work, or if they feel that they can't go into work at all and can't work through the pain, that they should ask their doctor for a doctor note excusing them for, at least a day or two.
Yeah. So you've got the liability set, and you have a reasonable handle on damages, but like you say, those things can continue to happen. There's, when is that when you start to put something together to talk to the insurance company to make a settlement demand? How does that work?
Yeah, so that's part of the patient's process as well. Is once that the treatment is either complete or at a milestone, we have to collect the medical records and assemble them as proof to the insurance company, and we do put it in a packet that's called a demand. I do not very much communicating with the insurance companies, at least the other driver's insurance company, before I submit that demand. I will communicate with our client's own insurance. Sometimes they have a line of personal injury protection that perhaps they're trying to cut off early. So I'll get involved with that. But as far as talking to the other driver's insurance company, my first real communication with them is the demand. And part of the challenges with that is getting the medical records. There's some providers who, there can be some red tape. One of the pieces of red tape is sometimes the larger providers, the accountable care organizations and such, they'll insist that you use their forms on the web, which puts a little bit of a roadblock up for us because when we sign the client, we have them sign releases for their medical records so that we can get them. A second issue, however, is if we contact a medical provider for them to send us medical records directly, they usually send us a giant bill. Sometimes it's for several $100s. Whereas if the client goes in and asks for those medical records directly, they can only charge them a reasonable copying fee, $7, $8, $9, $10. So I have a lot of conversations with our client about, hey, is it easy for you to go in and get these? Usually they'll give them to you on a thumb drive, or they used to give them on a CD, just so we can save that giant cost, that hundreds of dollars to get the medical records. So there's that. And then the last thing is you have to be sure with the client that you got everyone in there, because sometimes we're ready to fire off the demand and then I'll get on the phone with the client to review it and they'll mention a provider that they failed to mention beforehand. So advice to all personal injury clients: if you go see someone new as far as a medical provider, tell your lawyer so that they have it in their file so that they can get those records and process the demand.
I guess at that point, you sent them the stuff, you sent them why, their client is liable, why, what the damages are. Is there a certain number you put in the demand? It sounds like a dumb question, but I mean, do you say I demand X amount of dollars?
Yeah, I do. I put in a number in the demand. It's something that I speak with my clients about beforehand. And I say, I think this is a fair number. The insurance companies, they will never pay the first number that you demand. The only exception is if your client's damages exceed the policy limit of the other driver's insurance. So if I submit $150,000 worth of medical bills and the driver's policy limit is $100,000, that's the only time I will get an insurance company to say, here's a check, because they're getting off easy. They're not having to pay for $50,000 that needs to come now from another source. But if it's below the policy limits, and the thing is, in Washington, most people are driving around with the statutory minimum of only $25,000 in liability, which, given the cost of medical care, you could probably guess that does not cover very much. But you will get tons of pushback from the insurance company. They're supposed to respond to the demand in 30 days, come up with a number. If it's somewhere where I think we can get to a compromise number, then I'll talk to them. If it's a lowball offer, I'll usually call up my client and say, we need to sue these people. They're so far off. And when I say these people, I mean, it's actually a lawsuit against the insurance company. And I'll talk about that more later. But I'll say, look, I submitted, for example, $30,000 of bills and they're offering $5,000. They're so far off, we're not going to get there in the negotiation stage. I don't want to waste your time. We should probably go to court.
And that kind of leads to that stage, actually filing the lawsuit. I think a lot of people would be surprised to kind of hear, oh, that's the last thing you do, not the first thing you do.
Mm-hmm. True. A lot of clients, they're eager to go in and have their day in court. What I'll usually say to my clients is, court is expensive. Just to file a piece of paper usually ends up costing us around $500 to $600 for the filing fee and to get it served, depending on how easy the person is to locate. So when I explain to them, we'll pursue it as a claim first to keep the costs down, then they're usually on board with it. Not to mention, I feel part of my job is to keep my clients out of court. And that is to say, I like going to court, but I'm a lawyer. So that's not true of my clients. Court's intimidating for them. So if I can avoid having them brought in to a court proceeding, I will. One of the other issues when you file the lawsuit, I touched on it briefly, was service. You have to have service of process to make the lawsuit constitutional. It's a notification and an opportunity to defend oneself. And sometimes we have issues locating the person. They've moved. Usually it's that they've moved. Sometimes, though, they're evading service. And one of the issues you have to be really careful on is file the lawsuit sooner and don't wait for the 3-year statute of limitations. Because if you have a service issue that does not get resolved until the other end of the statute of limitations, well, there goes your lawsuit. And so you have to file these things at least 6 months, if not a lot more, before the statute of limitations, so you are certain that your service issues are all resolved and that your case can't be dismissed on those grounds.
It sounds like that kind of settlement demand, settlement, or deciding to go to court can be one of the more lengthy parts of the case, because there's a lot of moving parts, and and it is a settlement, and those drag on. So the last stage I think people really want to know about is, when do I get my money? It's, how are the proceeds distributed if you've had a settlement or you've actually gone to court and gotten a judgment?
Right. So that can be a little bit slow too. I usually tell my clients that they should wait at least 30 days to get a check. Sometimes it's longer because you can run into a lot of remaining issues, excuse me, lingering issues. Occasionally one is attorney's fees. You've come up with, either the jury or a judgment has come up with a number for damages, but there's something entitling you to attorney's fees. That's going to be a whole other extra fight, with it's a whole other set of court proceedings potentially.
Yep.
But otherwise, once you say you get a judgment from a judge or jury, a lot of times the insurance company will play games with you and say, well, we're going to appeal it. And then they will, excuse me again, they will make an offer that's less than the judgment to basically purchase your peace of mind that they're not going to appeal it. So they play games even after they get a judgment. But most of the times these cases are resolved through settlement or through arbitration, mediation, other forms of alternative dispute resolution.
Yep.
And then it's more like the 30 days. They will, sometimes there'll be an issue about who sends the check first, who sends the signed release first. In the end, it's rare that it's pretty much impossible that you're going to get in a situation where the client has signed a release and the insurance company won't send the check.
Right.
They will eventually have to send the check because once again, you might have to go back into court to enforce the settlement agreement and tell the judge, look, the insurance company was supposed to send a check 90 days ago, 2 months ago. And so it can get held up with that process. But if everything goes smoothly, the rules typically are they send it to the attorneys. That's the standard operating procedure for these types of cases in Washington. They send a check to the attorneys. We put it in trust until if there's any liens on it, as far as medical bills, we do have to pay those before we can distribute it to the client. And it tends to follow kind of old rules as far as checks. For example, we're supposed to wait a week for the check to clear, which is something that sounds like we're back in the 80s, 90s, and not a quarter of the way into the new century. Yep. It should clear right away, but because of the potential problems it could cause, we do wait a week for it to clear. So, once again, it's a game of patience, Steve.
Yep. It sounds like all the way through it's a game of patience. And I think talking about it like this, helps people to understand, just be patient. So, Andy, thank you so much for talking today with us about this. The 4 stages of a personal injury case, why having patience is important, why committing to it is important, and seeing it through is important. So Thank you very much for being here today.
Thanks for having me, Steve. My pleasure.
Oh, you bet. And thank you everyone else for joining us today. If anyone has further questions on this topic, you can post it. We can get you connected with Andy. And until next time, stay safe, stay happy,